Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, and thank you for stopping by. All right, guys, what we're going to talk about tonight is the whole NFA Hoover thing, and is this going to be the silver bullet that takes out the NFA completely? Now, this is incredibly interesting, and I would be remiss if I didn't mention the irony that the overreach of the ATF calling a piece of metal a machine gun led into this. That would be irony of ironies, but that's all the stuff that we're going to talk about. Everything is linked in the description box below. This conversation goes back 90 plus years to the origins of 1934 in the NFA Act. This is something that you guys need to know. There are so many nuances here, and we're diving into that right now. I cannot wait to hear what you guys think in the comments field below. Now, we are always looking to earn that subscription, so if you guys think we're bringing something to the table that will help us further our Second Amendment rights going forward, we'd love for you to consider subscribing. Thank you so much in advance, but now I'm going to say a quick word from our sponsor, and then we're going to hit it and hit so hard. There's so much to talk about here. Now, today's sponsor is Acre Gold. In today's economic environment, inflation is actively diminishing the value of our dollar and our savings. One way to fight inflation is investing in gold, and Acre Gold has a program to make gold affordable in order to preserve your savings against future inflation. Check out the link below and find out more, and thank you so much to Acre Gold for making the videos this week possible. But guys, let's dive into the monster that is the NFA. Now, brief primer, if you are not familiar, this is something that came out in 1934. The National Firearms Act essentially puts a tax on full auto machine guns, suppressors or silencers to some people, or SBRs or short barreled rifles. That's extremely high level. Okay? Now, essentially what they did was they created a program that made it a tax, and we're about to walk through a lot of those details, and that's why you have what's called a tax stamp. High level, let's dive in. Let me know what you guys think in the comments below. Send this out because this is interesting. Now, this is all coming out of a case with Matt Hoover. This is something where the ATF, like I said in the intro, overreached and said that a piece of metal with an etching drawing on it was an actual machine gun. That's the whole premise. He's in court. That's who we're talking about. And the lawyers have submitted a motion to dismiss this entire charge based on a few things. Let me know if I landed this plane correctly. Let's dive in. I cannot wait to hear what you guys think. Now, supplement to motion to dismiss and to declare unconstitutional the National Firearms Act of 1934. Now, like I said, that's pretty straightforward. And the National Firearms Act of 1934 is like the creme de la creme gun control. You get rid of that one, they don't have a lot left. But let's continue. To summarize, and this is from the motion to dismiss, any law, regulation, or government policy affecting the right of the people to keep and bear arms, Amendment 2, can only be constitutional if the government demonstrates analogous restrictions deeply rooted in American history evidenced by historical materials contemporaneous with the adoption of the Bill of Rights in 1791. Translation, you can't have any kind of restriction that was not there in 1791. That's the whole premise there. Bruin even says it. So this is bringing in the newest decision of Bruin. That's important to note. But let's keep going. We present the testimony of then Attorney General Cummings at a 1934 hearing on the National Firearms Act. Now, if you know the history of this is actually pretty damning evidence against the National Firearms Act, because we're going to start to get into a bunch of different things. We're going to start to get into congressional power to levy a tax, taxing a right, and poll tax and modern day stuff. There's tons of stuff here. But let's keep going. This is the actual testimony from the National Firearms Act in front of the Ways and Means Committee in 1934. Mr. Lewis, I hope the courts will find no doubt on a subject like this, in general, but I was curious to know how we escape the provision in the Constitution. How do we circumvent the Second Amendment? That's what that means. Attorney General Cummings. Oh, we do not attempt to escape it. We are dealing with another power, namely the power of taxation, congressional power, and of regulation under the Interstate Commerce Clause. You see, if we made a statute absolutely forbidding any human being to have a machine gun, you might say there is some constitutional question involved. Yeah, you think? But when you say, quote, we will tax the machine gun, and when you say that, quote, the absence of a license showing payment of the tax has been made and indicates that a crime has been perpetrated, you are easily within the law. Translation, we're just going to tax it. We're not going to say you can't have it. We're just going to make it more expensive. This is where the whole principle of that 1,000% AR tax came out of the Democrat from Virginia back when this whole most recent gun control push was coming from. Same principle. We didn't tell you couldn't have it. We're just going to make it a lot more expensive through a tax. That's what they're saying right here. Mr. Lewis, in other words, it does not amount to prohibition but allows of regulation. Here's what he said in response to that. That's the idea. We've studied it very carefully. The entire idea, even by the person who is testifying for the National Firearms Act and a lot deeper things here, says it's a tax, not a prohibition. It's a regulation, so therefore it's congressional, which makes sense in that translation because the National Firearms Act passed through Congress. It's an actual law. It's not an interpretation of the ATF or an executive definition. It is literally a law passed through Congress. But that's where we get really sticky, right? So when you're talking about all the different powers, the different branches of government, you have things in this that are referencing back to the Heller decision, because that's going to come up. In the Heller decision, which is in 2008, it came out and said you can have guns that were in common use, and it reinstated the McDonald decision, or excuse me, it reinforced the McDonald decision, going back to the entire, common use argument. If it's in common use, it's perfectly fine for everyday individuals to have. That was the whole idea. That was the distinction between the machine guns and the AR-15, for example. That was the idea. Okay, but let's get into this. Got one more thing. Again, they reference and see it coming with Heller. The government may attempt to argue that machine guns are beyond the scope of the Second Amendment by attempting to characterize them as dangerous and unusual. That's the Heller decision reference. As it is in other cases, but this is not the test. The court's invocation of dangerous and unusual weapons in Heller and subsequently Bruin was for the purpose of discussion of what might be a constitutionally accepted law rather than the endorsement of any particular extent policy. The idea that they're saying is, well, the Heller decision said it could be common use and you're going to say that, but because of the new Bruin decision, that puts everything else into a different perspective because you have to focus on history and text. This is an extremely complicated approach because you're dealing with the following things, and this is where it boils down to. You're talking about the congressional power to tax an item versus taxing a right. Now, they are 100% correct. Congress does have the power of taxation. However, does that mean that they have the taxation power on an actual right in the Constitution? Because as we've seen in modern history, poll taxes, which were a restriction on a right of voting, also unconstitutional. So when you see all of these things in this entire mixed mash of different rulings, different history, the historical text, and then you add in Bruin, you incorporate a little bit of Heller, you add in 90 years of gun control, and you've got one very interesting situation going forward, which I'll be honest with you, I don't know how it's going to end up because there's a lot of pros and cons from the approach of legal standard. And that's what I've got for you guys. Let me know what you think in the comments field below. Hopefully I landed that plane. It's a very, very complicated and intricate process and a lot of history here. But let me know in the comments field below if I did, and I will see you tomorrow morning on the bullet points. I'm Braden. See you later.